Welcome back. Today's explainer is an absolute game changer because we are tackling one of the most structured and, frankly, most powerful topics in all of contract law. We're talking about defeating contract formation using the big 8 defenses. If you've ever wondered how a seemingly ironclad agreement can just get completely blown up before the ink even dries, well, you are in the exact right place. Grab your notes because we are about to arm you with the ultimate legal arsenal.
So here is our roadmap for today. We'll quickly check the contract analytical path, introduce our secret weapon, the LDU MUMSI framework, break down the specific LDU, MU, and MSI defenses, and finish up by showing you exactly how to ace your essay exams.
All right, let's jump right into Section 1, the contract analytical path.
Okay, so whenever you're analyzing a fact pattern, you absolutely have to follow these 4 sequential steps strictly in order. First, determine the governing law. Are we using the UCC for goods or the common law? Second, you hit formation. Do we have mutual assent through offer and acceptance plus consideration? Now look closely at where defenses sit. They act as a massive stop gate right inside step 2. If a defense is successful here, it shuts the whole thing down. You might not even need to bother looking at alternative theories in step 3 or performance in step 4.
And this brings us to the strict chronology of the law, what our sources brilliantly call the rule of no backsies. Literally, once you clear that formation stage without raising a defense, there are absolutely no backsies. Whatever happens later during the performance phase cannot retroactively undo your completed formation analysis. That is exactly why spotting these defenses early is so crucial.
Moving right along to Section 2, introducing LDU MUMSI and outcomes.
Grab a screenshot of this, seriously. LDU MUSC. It's a slightly goofy acronym, I know, but it is fiercely effective. These are your big 8 defenses to contract formation. Remember, an affirmative defense basically says, sure, a factual agreement might have happened, but it has no legal effect. Whether it's lack of capacity, duress, undue influence, mistake, unconscientiability, misrepresentation, statute of frauds, or illegality, any one of these 8 can entirely torpedo a valid agreement.
Now, what's the actual outcome if you nail one of these defenses? Well, the contract becomes either void or voidable. If it's a void contract, the law treats it like it never existed at all. Poof, gone. Neither party can enforce it. But if it's a voidable contract, it remains enforceable right up until the adversely affected party actively takes steps to rescind it. That means the victim actually gets to choose whether to keep the deal or kill it.
All right, Section 3, LDU, capacity, duress, and influence. Let's break down those black-letter definitions.
First up is the L for lack of capacity. The core rule here is that a party must actually have the legal and mental capacity to consent. If they don't, maybe due to infancy, like a 16-year-old trying to finance a sports car, or due to mental illness or even intoxication, the law steps in as a shield. And a quick tip on that intoxication piece, it generally only works as a defense if the other party actually knew you were intoxicated and couldn't understand the transaction.
Then we have the D for duress. This is all about being backed into a corner where saying yes was literally your only way out. The black-letter law defines it as assent obtained through an improper threat that leaves a party with no reasonable alternative. Now, that threat can be physical, sure, but it can also be totally economic, like a bad faith threat to breach a contract just to financially ruin the other guy. Rounding out this trio is the U for undue influence. Unlike the blatant threats of duress, this one is a lot softer. It's more manipulative. It's the unfair persuasion of someone who is either under the domination of another or in a confidential fiduciary relationship. Think of a really aggressive caregiver pressuring an elderly patient into signing over their estate. It's an abuse of a pre-existing trust. Next is Section 4, MU, mistake and unconscientiability. These are basically the ultimate fairness checks. The first M is mistake, and the big distinction you have to make here is between mutual and unilateral. If both parties mistakenly think they're buying and selling a genuine Picasso and it turns out to be a fake, that's a mutual mistake, and it's voidable. But if only one person makes an error, a unilateral mistake, they are usually just out of luck. It's only voidable if the other party sneakily knew about the mistake or actually caused it. Next up is our second U, unconscionability. This is such a fascinating doctrine. For a contract to be deemed unconscionable, you usually need 2 prongs. First, procedural unfairness, meaning unfair surprise, lack of meaningful choice, or a massive disparity in bargaining power buried in the fine print. Second, substantive unfairness. The actual terms have to be so heavily one-sided and oppressive that the court literally refuses to look at it. It has to, as they say, shock the conscience of the court.
Okay, Section 5, MSI. Let's knock out the final letters: misrepresentation, frauds, and illegality.
Our final M is misrepresentation. Put simply, if someone lies to get your signature, like a dealer rolling back the odometer on a used car, that's misrepresentation. It perfectly highlights how absolute truth is foundational to mutual assent. The specific rule is pretty cool. If a false statement is made fraudulently, it doesn't even have to be a material fact to void the contract. But if it was just an innocent or negligent slip-up, it must be a material fact that actually induced you to agree.
Then we hit S for the statute of frauds, because sometimes a handshake just isn't going to cut it. The law demands paper and ink. If a contract falls under the statute, it is unenforceable without a signed writing. You can memorize these specific categories with another fantastic mnemonic from our sources, MY legs. Marriage, contracts taking over a year; land, executor duties; goods over $500; and suretyship, which is paying the debt of someone else.
And finally, the I stands for illegality. This one is rigid. If the agreement's subject matter is prohibited by law or violates public policy, it is dead on arrival. And here's the kicker. If it's an illegal contract, like a deal for illicit drugs, the courts won't even help you get your money back through restitution. They leave the parties exactly where they found them. The money is just lost.
Finally, Section 6, acing the essay exam. Now that your LDU MSI arsenal is loaded, how do you actually deploy it?
Our sources highlight a massive warning about what they call the cutoff. When you are writing an essay focused on formation, you have to stay disciplined. The material stops exactly at the statute of frauds. Do not fight the question by dragging in advanced performance topics like the parallel evidence rule or conditions. If you go off script, you're going to get zero credit for those sections. Just stick to formation and your Big 8 defenses.
So what does a winning essay actually look like? It's highly logical. You start by identifying the common law or UCC. You hit mutual assent with offer and acceptance. You find the consideration. And then only then do you cleanly apply your LDU MUMSI defenses using the IRAC method. Issue, rule, application, conclusion. It's a precise, step-by-step formula.
When it comes down to it, think of these defenses like tactical maneuvers on a chessboard. They are highly structured, totally logical, and incredibly satisfying to use once you know the rules. Master those black-letter definitions, trust your LDU MUMSI framework, and whatever you do, do not fight the prompt. I'm going to leave you to ponder this final thought as you memorize your Big 8. If an agreement passes the mirror image rule, and it has perfect consideration, but it completely fails the test of fundamental fairness, was there ever really a contract at all? The law says no. Keep learning, keep organizing those notes, and I will see you in the next explainer.